afternoon, good evening, wherever you are. Welcome to the Two Tokens podcast. We have a veritable bevy of experts here today to talk about MiCA and other aspects of cryptocurrency and blockchain legislation. I'm joined by Willem-Jan and Karsten. Guys, why don't you introduce yourself? Willem-Jan.
Thank you, Ryan. Yeah, my name is Willem-Jan Smits. I'm a lawyer working at Watsonlaw, and I'm specialized in crypto regulation.
And Karsten, how about yourself?
Thank you. Great to be here. My name is Karsten Bruinsma. I'm working at CMS in Amsterdam. Also a lawyer, so you're having two lawyers in front of you today. And I'm active in the Fintech sphere, giving advice to a lot of token companies, crypto registrations, where we are assisting with. That's what I do.
Okay, I think I was justified when I said we've got a room full of experts. I'm Ranking, I'm head of business development at Dusk Network. So we're a zero knowledge proof, compliance and privacy built-in layer one blockchain platform. And I'm happy to be talking to you guys today. Now, let's just assume for a second that everybody listening in is relatively new, relatively unfamiliar with the legislation. Let's go back from the very beginning. Let's talk about MiCA. That's the big one that everybody's been discussing at the moment, the markets in crypto assets legislation. Willem-Jan, could you give us a bit of an introduction about what MiCA is and what does it cover?
Yeah, so MiCA is a regulation that covers basically the entire EU crypto market. Till date, we don't have any real crypto regulation. And this piece of legislation will cover the entire market. What we see in traditional markets for the issuance and listing of tokens, for giving advice, etc. There's a lot of legislation about that, as well as market abuse. Those are all developed over the last 30 years, and now we see this for crypto as well. So it's a piece of legislation that will cover the entire market. And so let's together dive into it. And maybe Karsten, you can tell something about a little bit of crypto regulation that is already in place with AML and sanctions regulation.
Yeah, sure. Different from the upcoming MiCA legislation. You're talking about the traditional financial instruments that are regulated in Europe and in the Netherlands. And there's now only an AML kind of check on these crypto exchanges in the Netherlands and in Europe. And these crypto companies they offer crypto wallets or the services for exchange. And what is now the case, they all need a registration in every European country and to perform these AML and sanctions checks. And if they receive such a registration, they can offer these services in these countries. And this gives a lot of hassle to these companies because they have to go through this process in every country. And this is something what MiCA hopefully will solve. It will be possible to passport these services to other European countries. And this is something that is not the case at the moment.
So very useful indeed. Certainly good for the future, and it makes sense as well, doesn't it? Because we talk. I mean, of course, this is something that happens in countries all over the world. The US has its various regulations, China has its regulations, but those countries very much operate as singular nation states. We're talking about a multinational trading bloc that somehow is not unified at this digital level. Do we think this creates a bright future for crypto in Europe, or does it go the other way and perhaps maybe discourage innovation? Willem-Jan, what do you think?
To take it a little bit of a step back, what we now see, and what Karsten really mentioned, is that there is really a patchwork of crypto regulation in the EU. So there is a directive that is indeed implemented in 27 member states, but it's implemented in a very different way. Some countries are very strict, such as the Netherlands, France, but there are also countries that are much less strict. There are even countries that have their own blockchain laws, such as Germany, Malta, Estonia. With MiCA, the most of this will most probably disappear in the long term. So we see just a level playing field, and that's what we obviously like to see as lawyers, so our clients can visit all Europe and get into the entire market. Preferably, what's the ultimate goal is that there will be a global legal framework for crypto, because these markets aren't only in Europe, they are worldwide. But I think that's utopia for the next decade. But to answer your questions, I think that in the long run, this is something very good for the industry. Legal clarity and the same legal framework. But there have to be ironed out a lot of small things before we are there.
Right, indeed. And Karsten, you're also handling MiCA and current DNB registration requests from clients, presumably. How do you find those two? Is there a lot of confusion about how those interact? Is it fairly clear? Do you feel that there's been a good job made of explaining this to the public? How are your clients dealing with this at the moment?
There's a lot of uncertainty at the moment because how it is now stated, like the crypto registration will stay there and will be next, besides the other requirements in MiCA. And what we see in traditional European financial legislation is that this will be included into one license application. But for now, this is not clear, and we get a lot of questions also from parties that want to enter the markets in Europe, in the Netherlands, from, for instance, the US or Canada. They ask us, can we wait until MiCA comes in and we can passport our services to all the other countries in Europe, or do we still have to do the AML registration in all those separate countries?
Right.
And there's no real guidance on this. So this is something that really needs to follow in the next few months to give all the market parties the certainty on that topic.
Indeed, this is one of the crinkles that needs to be sort of ironed out. I mean, there's no point having this unified system if we still have these separate systems. It reminds me of I think it was one of the American presidents who joked about, he said, who do I call if I want to speak to Europe? Sort of. So as we mentioned before, we very much what this whole European project about, right, is creating these multinational opportunities, a market of 455 million people, single largest GDP in the world. It's a great opportunity, but you have to be able to have one set of laws, one set of regulations that works across the whole country. And this also comes down to back to our compliance issues as well, doesn't it? Like, how do we integrate that into technology itself, or how do our clients sort of work on that from a license and registration perspective? So big crinkle to work out. Let's talk about any other crinkles you've spotted. Willem-Jan, do you have anything particular that maybe concerns you or even interests you?
Yeah, there are quite some things, but maybe it's nice to pick out a couple and run through the different pillars of MiCA. Maybe good to mention is the issuance and listing of crypto assets is obviously an important point, also for, like you mentioned, for the audience of two tokens, stable coins, CASP, so crypto asset service providers, and market abuse part. So, Karsten, if you want to pick one, so
maybe the market abuse is something.
It's a good one.
I think that's very important for the crypto and token scene. To have that like more professionality on that side, because crypto has sometimes the people around are stating that it's quite money laundering with it and other things. It's very good for the crypto sphere, I think, to have this more professional rules and to have the consumers protected, especially insider trading, market abuse. To have this on a level that we're used to in Europe and with all the traditional financial instruments.
Yeah, a great point there. It's a very good thing you mentioned that. Indeed, we don't have to avoid this issue. We know that there's a lot of insider trading and market manipulation going on in the market. Maybe not so much anymore on really large centralized platforms, but in any case, in the decentralized part, the AML part is being covered, so to say, already in the last couple of years. But this is really the first step towards market abuse, right? And if you compare it to the traditional markets, it's thousands of pages of legislation, and in MiCA it's only 3 or 4 articles. So it's a first step.
Yeah, doable. Yeah,
it's doable for the market. That's a good thing. But you can already figure out that MiCA 2 will be there in a couple of years, and that this matter will be expanded far beyond what we see now. And I think the chairperson of the AFM already mentioned it, that this is an issue that she believes is not covered appropriate by MiCA, because there's barely any reporting on transactions and manipulation, so that the NCAs can't look into what's happening, and I believe they don't really have a good feeling about the markets on that point yet. But it's a first step, and like with any market, you have to start somewhere.
Yeah, you have to start somewhere. I think we had a couple of discussions. We've chatted a few times before about how it seemed sort of almost like that final draft of MiCA was almost just kind of getting something out of the door, right? It's similar to how startups build like a very early version of a tech product, and it's terrible, right? But it performs 1 or 2 bits of functionality that you can build on in the future. It was if I remember correctly, right at the end of France's presidency.
Correct. Yeah, in June.
Was it almost the last day or very
the last
close?
2 days? Yes.
Right. So get the business done before we hand over the presidency. Make sure we get the credit. Almost. Let's be honest. Maybe
probably that will be there as well. Yeah. Maybe to put that in a little bit in a framework, that September 2020, the Commission issued the first draft on MiCA, basically setting the goalposts. And later this year, earlier this year, in March, the European Parliament came with amendments and with basically a report on that. That's basically the final draft, the last version of the draft that we know at this moment. And then the 3 institutions of the European Union, so the Parliament, the Commission, and the Council, they entered into a trilogue discussing these 2 drafts and coming up with a political deal. And that I feel has been pushed indeed to a deal before the summer, while not everything was covered correctly. And at this moment, they're working out the final draft, so we don't know it. It's quite,
Still could be some surprises.
Definitely, yeah.
And hopefully not big ones, but still possible. Yes, exactly. I think that was a great point to make, as you say, it was sort of coming to an end. I think you used the word political deal. Yeah. Like ultimately, at the end of the day, 2 people just need to reach across the table and shake hands and say, let's just get this out. Yeah. 3 people have to somehow shake hands and get it out the door. I remember when it came out, there was a few question marks, a few things popped up. The sustainability requirements were sort of kind of kicked down the road, maybe, I suppose would be a nice way of interpreting it. And the blacklist and the stablecoin cap, these all popped up along with a handful of other things. Karsten, was there anything about final draft of MiCA that particularly surprised you, or did you think it was a fairly good deal at the end of the day?
So we're not 100% sure what is in there. We only know the final draft, and I think this week was published that in 4 to 6 weeks we will have like the final draft. So we hopefully takes away some of the uncertainties. But one of the topics, I think, at the end they were still discussing to include NFTs, or whether they should be included. And for now, they are not included. And this is something that I think will stay the same, but we're not 100% sure.
Yeah.
It could be that it has been changed in the last few months. Yeah, that's something I'm curious about. Yeah.
It's very curious. Now, I am interested in your opinions on this, because this is not meant to be at all a criticism, of course, of you guys. I mean, a criticism of the system, but also just an observation. This is one of the things we see run into when we talk about technology meeting legislation, is legislators, politicians move very slowly, technologists and builders move very quickly. So we talk about NFTs. NFT is a great point. If you think about the time from basically when almost nobody outside of a very small niche group of people had even heard of an NFT, who even knew what the word fungible meant. We don't use it very commonly in English, right? To this craze. And you think this is probably shorter than the period of time between a MiCA 1 and a MiCA 2. So the real question here is, will this legislation always be playing catch up?
Yeah,
Karsten.
I think with legislation, it is a bit like this. And maybe, to add on your point, it is not even necessary to regulate NFTs in a few years. Maybe they're not. We don't know. But it's a fair point to say that the legislators always a bit behind the practice. Yeah.
Yeah, I think per definition in tech law, right, the law lags behind technology. Market goes so fast, so that's here as well. And the NFT part, it's a good point. I think if the legislator could start over, they would most definitely include it, this. But if you look at how it's excluded currently in the last draft, then it's really debatable whether it's not 95% of NFTs will fall in the scope of MiCA, because they're really talking about non-fungible, and what we see with most NFTs is that they are launched in a series of sometimes thousands or even 10,000 tokens, which are then in most cases fungible with each other within the series. So it's, in my opinion, debatable whether those are non-fungible tokens within the meaning of MiCA. And also, it's stated there that they shouldn't be listed on an exchange, which is, I think you should consider OpenSea and those kind of platforms as an exchange. Then 95% of NFTs are actually meant as investment objects, not in the legal sense of the word, but in common sense of the word.
Mm-hmm.
And it's a good thing that those types of tokens are indeed covered, in my opinion, under MiCA. There's no real reason to let them out. And I think, there's a good point to make for NCAs to interpret the draft in such a way that they are actually included. But let's wait what the final text will look on this matter.
That leads into another great point. So NCAs, people listening, national competent authorities, are sort of the body within the member state that's then responsible for enforcing this, your kind of sheriff's deputies, if you will. What kind of leniency, if any, will they have in interpreting this law vis-a-vis their European counterparts, do you imagine? Will there be a lot of leniency, or will it be very clear they just have to execute the work that they've been told to do?
They have some independency on that, especially I think with the license that will be granted. And you also see that with like the investment firm licenses in Europe, there are some differences between the countries in Europe. But for instance, the white paper that should be published with the issuance of certain tokens, they have only the authority to reject it. So there's no, it's different than we used to with the prospectus and the issuance of securities in Europe. So I'm curious how this will work in practice. I think there's only an obligation to share your white paper 20 days before publication with the authority. And they can just only reject it, but not. There's no real discussion between the authority and the issuing parties. Yeah,
It's an interesting point. I'm really curious what's going to happen here, because under AMLD5, the registration, what we discussed in the beginning of this conversation, in the actual directive, there's only a few lines about this registration thing, and it in Europe it basically turned out as a licensing obligation, right? Especially if you look at the Netherlands, DNB goes line by line through hundreds of pages of documentation, and says what you should, on what points you should amend it, etc. I view it in practice as a licensing obligation. What's here in the text is that I'm curious how the NCA is going to handle this, because if you see that someone can reject it, that they can reject a white paper, then that's basically the opposite as approve it. They can just reject it if they don't like it and say, okay, if you don't amend this, we will reject it. So I'm curious to see the stance of the NCAs, and whether there will be a difference between member states. There shouldn't be, because everything is looking to get a level playing field. But we also in traditional markets we see regulatory arbitrage. So that will be the result if there's one NCA interpreting things in another way than the other one.
Yeah, and it could
do you see this?
I agree with you that with traditional markets and licenses, there are some differences between the countries and the supervising authorities. There shouldn't be, but there are. So indeed, I'm curious to see how this will end up in practice. Yeah.
We'll know in a few years.
A few weeks, but probably.
I think a few years before it's in practice. Yeah.
No, indeed. Yeah, it is expected, I think, in the first half year of 2024.
Yeah. So, and I think another interesting point on issuing tokens and getting them listed on exchanges is the liability of issuers for white paper. Typically, let's say it this way. In MiCA, it is stated that you cannot limit your liability as an issuer on this point. So an issuer of a token, or a token that wants to have its token admitted to a trading platform, has to issue a white paper and publish it. If there's anything in there that isn't appropriate, and on the basis of that someone takes a decision to buy those tokens and is damaged, that liability cannot be limited. But that not only goes for tokens that are issued by a certain party, this also goes for tokens that are or crypto assets that are just listed on a platform and don't have an identifiable issuer. So, for instance, Bitcoin.
Yeah.
If a platform wants to add Bitcoin to it as a trading pair, then it has to publish a white paper, and also there it goes that it cannot limit its liability for this white paper. So that is quite a harsh thing. And maybe, Karsten, we should together work out a brilliant white paper.
No, that's indeed that is a very good idea, and I'm very curious to see, because the platform will for sure take away all the liability for those white papers. So there will be a big role for lawyers, I guess, to assist with that, because there's no real party probably sometimes that can take the responsibility, and the platforms don't want to take the responsibility. So that's something we have to see how this will end up.
Yeah, it's a bit of a strange thing, of course. Requiring just a trading platform to issue information on these assets, especially since they are out there already for such a long time, and it really places European service provider or European exchange platforms in a weaker position than than outside counterparties.
Definitely. It also struck me a little bit as a very strange. I mean, why would you, as a trading platform, why would you want to be responsible for something that you have no control over whatsoever? It's insanity. But anyway, quick word, and I mean a very quick word, because I'm aware of the fact the people listening in, of course, won't know, but we're recording this on the same day as the Ethereum merge. So proof of work was another thing we saw, maybe some future direction towards. Where do you see that going in terms of MiCA? Is this a MiCA 2? Is this a 1.5? Is this an investigative committee at some point?
In the European Parliament, there has been a debate, and there has been a proposed amendment to include a ban of proof of work consensus algorithm in this regulation. In my opinion, that would be catastrophic. Place the EU completely out of the market. It's absolutely no market practice, and it has no place in financial regulation. Luckily, this didn't make it, and instead, various parties that are touching crypto assets with proof of work consensus algorithms have to provide information on that. Fair enough, and it will be included in the European ESG taxonomy. I'm not an expert on that. You just mentioned that you were advising on that, so maybe you can.
Yeah, no, there's still, we discussed the European legislation process, and this is like the European sustainability regulations are also the last few years.
Are they still in draft?
Yeah, no, they are in force, but
Okay.
there's still a lot of technical standards that are not like worked out. So yeah, the same uncertainty is there as well. Yeah, so we don't know yet how this will be combined, especially as well with the crypto legislation. Yeah.
Okay. Yeah, well, as I understand it, this will be mostly information that has to be provided.
Yeah.
And we're not quite past this point, because there will be an evaluation by the Commission on this topic. I believe in 36 months after the regulation enters into force. But this thing doesn't come from the Commission, so it's not an idea that is their ownership. So from that angle, I have good hopes that it in fact will end here. But there will be, like I said, there will be an evaluation, and this matter will pop up in approximately 3 years.
Okay, well, I guess we'll probably have to meet back in 3 years and talk about it. Final thing to mention then. So I think it's very interesting. I mean, from a almost a meta perspective, that we're sitting here talking about a piece of legislation, and yet the consequences of this, at least what we've been talking about, is all along the lines of uncertainty, right? So we've been talking about the drafting of a law, and yet most of the topic of our conversation has been uncertainty. So we have this uncertainty. We also have a lot of possibilities, a lot of different ways it can go ahead in the future. I'd love to get your very, very quick opinion on if this is, what do you see? Is it overall positive and overall negative? Where does it take the market, Karsten?
No, I'm quite positive about it. I think it will make the crypto market more professional, and it will be seen more as like a traditional investment product, and I think that can only be positive, for all the crypto companies and the crypto world.
Great.
Yeah, so I'm very positive about that.
I agree with Karsten. If we look at this back to this moment, I guess in 10 years' time, probably we'll be discussing MiCA 3 by then. I think that MiCA will have a positive impact on the market, less patchwork, better protection for consumers, better market integrity, also more institutional parties entering the market, really using this technology. So I think it's for Europe a good thing. I also believe that also other markets as the US will tag along with this initiative, as we've seen with privacy regulation. So all in all, I think in the long run, it's basically a good thing.
Okay, very positive sentiment. Well, luckily, I share that sentiment. I think this is really great for bringing in, as you mentioned, traditional finance, decentralized finance sort of together into a sort of like you say, a more, bringing more certainty into the market, seeing things as traditional investment products. I think overall, I share your opinions, and I hope that we're all right. So let's meet back up in here in a few years and look back and see whether we were horribly wrong or hopefully very, very correct, maybe even under optimistic. That'd be the best thing. Thanks for joining us today, Willem-Jan.
Thank you for having me, Ryan, and thanks for hosting this podcast.
No problem, and thanks, Karsten.
Yes, no, thank you very much for having me. It was great fun together.
Great, and thanks to everybody for listening. We hope you really enjoyed it, and we'll see you next time on the Two Tokens podcast.
That was it